M.A. Sumanthiran, you have 22 minutes.
Thank you, Deputy Chairman, for the time allocated for me to speak on this very important bill that has been presented by the Minister of Justice today. I'm saying important bill because for a long time the need was felt that the issue of contempt of court needed some intervention by the legislature so that what we thought was the application of the common law of contempt with all its uncertainties will be regulated better, particularly with regard to the procedure one adopts in the superior courts. The Civil Procedure Code has a chapter that prescribes procedure for inferior courts, and therefore there is some procedure prescribed. The Judicature Act prescribes limitation with regard to sentences that can be imposed, and in any case that is in facie contempt that they can try. Anything outside of that court, unless specifically authorized by law, our Constitution has given the jurisdiction to the Court of Appeal to try those. The superior courts of record, both the Supreme Court and the Court of Appeal, have adopted their own procedure in dealing with this issue. We have seen in the past, not very long ago, when the Supreme Court, in the exercise of its fundamental rights jurisdiction, has summarily detained persons without a charge being read out, sent them to prison, and tried and committed persons to judicial custody, holding them in contempt. This happened in one particular case, or two cases, if I remember right. One with regard to sand mining, and the other with regard to sound pollution, where the then Chief Justice Sarath Silva, presiding in the Chief Justice's court, would entertain even photographs that somebody gave, look at it and say, here you have done sand mining, and sentence the man to prison. These things happened. It was important to lay down a procedure, particularly the right to be heard, and the right to be heard, we understand, in a very substantial manner before a person is condemned. And also with regard to punishments, there had to be some direction, some limitations, rather than leave it to the court to decide as they pleased as to what kind of punishment must be meted out when a complaint of contempt comes before court. Unfortunately, although in the original bill that issue has been addressed, the Supreme Court, in a special determination, seems to have suggested that that limitation is contrary to the constitutional provision, and that it requires a referendum. And therefore, the Minister is moving an amendment, committee stage amendment, which has been given to us, removing those limitations in the punishment. This is very unsatisfactory. It's ironic that we discuss conferring jurisdiction already. It's already conferred through the Constitution, but affirming that the court must have a right to punish for contempt, but also in the same proceedings here in Parliament express our dissatisfaction with regard to some of these special determinations. That doesn't lower the dignity of the court. There must be at least one place where this must be discussed. And it is not only in Parliament that we can disapprove judgments of court. There can be academic discussions outside Parliament also. That's not contempt. You can disagree with judgments. And this is one such instance. I believe that one of the core purposes of bringing a statute is defeated when you leave those limitations of punishment out of this statute. We have had instances when court has acted with anger, not with restraint, not with proportionality. So that is why it is important that we put down in the law the categories of offences of contempt and limited those punishments. And I think the original limitations were good: 6 months, 1 year, and up to 2 years, and not more than 2 years. Unfortunately, that is not being, we are not being able to do that because of the Supreme Court itself. And today is an instance when in this House, conduct of judges and court was taken to the cleaners by a cabinet minister, no less. Often we have found the members of the opposition saying things, or if a government member said something, there will be objection raised based on standing orders that you can't do this. But today, the gravity of the subject was such, not one single member of Parliament objected. The Deputy Speaker who was in your chair felt uncomfortable, and at one point merely drew the Minister's attention to Standing Order 83. That's all. All what he wanted to say was said, and that is a reflection of the sad state that the judiciary is also in today. And I don't think we should back off thinking that if we discuss it here, that is in some way an affront to the judiciary. No, it is not. After all, it is a Parliament that gives the judiciary judicial power. The Constitution has given. That was enacted in this Parliament.
Order, please. Honorable Sumanthiran to the chair.
In any case, the judicial power of the people is vested in Parliament, and it exercised through courts and other institutions for the administration of justice. Therefore, the Parliament has a special task to discuss these matters. I want to draw the Minister's attention to developments in other jurisdictions. Now, it's well and good that in order for judicial orders to be obeyed and respected, that you have provision to punish those who violate court orders. But the offense of scandalizing the court, or whether scandalizing the court should amount to contempt of court, is a matter that other jurisdictions have looked at, and in many places it is no longer a part of the offence of contempt. England and Wales removed that as part of the offence of contempt in 2013. That is because the idea of free speech, expression, and accountability of the judiciary to even defend the orders that they make are seen to be an important element in a democracy. I have the report of the Law Reform Commission of Victoria, which came out recently, just last year, so that is why I have that document, that has serialized how in other jurisdictions the scandalizing contempt has been removed from the law. But in certain places, they have allowed it to remain, but with very limited application, limited need to protect against statements that impair public confidence in court. The whole idea is that public, the confidence that public have in the judiciary must be earned. They must demand that confidence in themselves by their conduct. It's like respecting your elders, right? Or anybody else. By their very conduct, the citizens will give them the due recognition and respect. It is not forced out of them. And in certain issues, perhaps in certain areas, judges come out and explain. And some countries have passed laws where it is made obligatory to explain. Our law also says judgments, you must give reasons. That is the underlying principle. Why should you give reasons otherwise? You can say, well, the court has the power to rule, it has ruled. And that is why even today, in certain instances when court refuses, particularly refuses leave to proceed in fundamental rights cases, we ask for reasons. In most cases, they don't give reasons because it's not obligatory. But you must give reasons. We've had fundamental rights cases at leave stage itself argued for 10 days. Surely, to argue for 10 days, there was reason to look into the matter. After full 10 days of arguments, full bench has said, we see no reason to grant leave to proceed. That's the only reason. That shouldn't be. Matters of public importance, they must give reason for their decision. Now, the Supreme Court and the Court of Appeal supervise judgments of inferior courts. And if their reasons are not given, that in itself is a ground for appeal. That in itself is a ground. We go and say, well, they haven't given reasons. This issue hasn't been dealt with. But that must apply equally to the superior courts also. Because the accountability is to the people. The judicial power, one has to understand, is the power of the people. And when we say it is the power of the people, that must have some meaning. For judicial independence, it is true that when a judge is appointed, he can't be removed except through special procedures. All of that is there. But that doesn't take away from him or her the obligation to answer to the people, because the function that they perform is a function of the power of the people that have been given to them to perform. And they must constantly give account to the people of what they do. So this morning when we had these sittings here and various comments were made, it brought the judiciary into disrepute. Tomorrow or today, even when people have seen this and what was discussed in this, these hallowed precincts, people will regard the judiciary with contempt. But I'm not making any reference to this particular case. But if courts have conducted themselves in such a way, like the instances I gave earlier, the same former Chief Justice Sarath Silva, after he retired, on a political platform said, Hiragedara yavanna hitiya ekanawa mama rajagedarata yawwa. Mama samawa illanawa. Janatage samawa illanawa. Now he should have been sentenced to prison for that. For abuse of judicial power and public confession. Another one who sat in the seat of the Chief Justice, later it was resolved that he was never properly appointed Chief Justice. A former president publicly said that he came to the president and said, don't remove me from this post, I will hold everything in favor of the government. And the president said that. President Maithripala Sirisena publicly said that. Now, when you have people who have sat in the seat of the Chief Justice, the head of the judiciary, who have behaved like that, is it any wonder that people have only contempt for court? Is it any wonder? So what are we trying to do then? We are trying to forcibly, this is like the policeman in the magistrate's court who thinks that you mustn't cross your leg, you mustn't read a book. He thinks that is contempt. A false idea of what it means to respect court. So that is why I think the issue of scandalizing court should be removed from this. Enforcing a court order, violating a court order, yes. That may be visited with punishment. But scandalizing court in today's age is not something that should be there. Other civilized jurisdictions are little by little removing them. This is the other reason why even the online safety bill, when they had put in this contempt of court also, we argued before the Supreme Court that that should not be there. Free expression must be permitted. When it exceeds bounds, there will emerge a societal pressure, a community restriction that will somehow regulate that. Not everything can be regulated by enforcement of strict law like this. Again, unfortunately, we cannot agree with the determination of the Supreme Court in regard to the online safety bill. Very serious concerns have been raised, and many of those serious concerns, there are a record 54 petitions filed, 45 counsel. One day court sat till 10 in the night. I mean, they have written a 62-page determination, but many of very crucial issues raised by the petitioners are not dealt with in the determination. So where can we say this? I mean, can say it anywhere.
ඔබතුමා තව ඇත්ත විනාඩි 2ක කාලයක්.
Thank you. But While commending the minister to have taken the step towards a long felt need of a statute that prescribes procedure, we thought we'll prescribe punishments also, but at least the procedure is prescribed so that a person knows that if he is accused of contempt, there is at least a procedural safeguard. But as it is, you are going to remove the limitation on punishment, leaving it to court to even pass death sentence for contempt. Strictly that is possible. That should not be the case. Another matter is a limitation of time. A very salutary provision was in the original draft that within 1 year of the alleged offence, the complaint should be made. But now it says court must take action within 1 month from it being reported to court. So 30 years after an alleged offence, somebody reports it to court and court has to then within one year take action. That's how it will read. How can that be when penal offences themselves have a restriction of 20 years, that this has no restriction at all? From the alleged offence, there must be... I'm concluding. There must be a limitation of time. So while welcoming this, I urge the Minister to take necessary steps to remove scandalizing contempt from this, to somehow, even by amending the Constitution if necessary, have limitations on the punishment and to bring in limitation of time. Thank you.